Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at an exciting book. It's one I found fascinating to look at. The title alone evokes an awful lot of interest. It's called Whistleblowing, Law and Practice, 3rd edition. Been written by a number of people. It's a scholarly work. People involved are Jeremy Lewis, John Bowers, Queen's Counsel, Martin Fodder and Jack Mitchell. As I say, Oxford University Press have published it. It's a very interesting book. Whistleblowing is a controversial area in its own right. The difficulties about whether they should be given protection, all sorts of main policy issues are looked at in great detail. But the end result of this is always going to be the jurisprudential nightmare about balancing one thing against another. If you blow the whistle on someone, and it's not football we're talking about here, if you actually uncover something, it's the issue about uncovering a greater wrong, possibly by committing a lesser wrong. And that juggling, in terms of legal theory and jurisprudence, it's always been with us, and it's always going to be with us, but it's a lovely bit for us as academics and practitioners to get our teeth into. Now, I like this book immensely, as you probably gather. Elizabeth actually wrote the main review, but we had a long discussion about the book, and I've given it the title for our book review, The Definitive Work in This Evolving Area of Law, because it is evolving, and this is now in a new 3rd edition. Let's look at the book first of all. It's a hardback, blue cover, there we go. It's a big book, this one. There's the front page, there's the spine. Now, it's running to something approaching just under 800 pages. The index at the back is by paragraph numbering. It's very much the house style of OUP, but again, it's a detailed index. Then you've got, after the index is right at the back, and then you've got some appendices, 3 appendices, which I'll mention. We'll go to the front of the book next, and that is here. There's the main front page. And then you've got some information about Oxford University Press. And then there's a dedication, which I shall just put up close to the camera. You can see the author's wish to dedicate it. I think the dedication is very important. There it is. And then we've got a foreword from Sir Maurice Kay, who will be known to many of you, editor of The Civil Practice, amongst other things. Again, an OUP publication. But he's given some very useful information. It's a tribute to the authoritative standing of this work. It is now in its 3rd edition after a decade after its first publication. Then you've got the main preface. Then you've got, from the authors, then you've got the summary of contents. Then detailed contents. So you shouldn't have too much difficulty finding things. Table of cases, plenty of them. And then you've got, after that, some legislation, naturally. And after that we get to the book itself. Now you see, chapter 1, there's the heading, introduction of course. Then what you have got is a nice index of what's in the chapter. I do find that very helpful, because when you're looking for things, for instance, it's looking right at the beginning at the Shipman inquiry. So it's dealing with very serious issues here. You've got the paragraph numbering on the side there. You've got footnoting, of course, as to be expected. The 3 tiers of protection, which are covered there. You've got the right not to suffer detriment. I'd love to know how you actually enforce something like that, but there we go. You've then got remedies in dismissal and detriment claims and so forth, and it runs all the way through. The European Convention on Human Rights, of course, gets a good look in. We're not going to be moving out of that, whatever you think, for a long time. Whistleblowing procedures, another area, very interesting. I found the book fascinating, and there are at the back some precedents and some in Appendix 3, some cases in Appendix 2, and in Appendix 1 we've got a case study. There we go, which is there. All in all, a very interesting book. And I don't see this subject going away. I think it's very important. There's politics involved in this. You've always got to take the view that many do, always try to avoid the politics of something. But I'm afraid it's difficult with something like this, because when you're dealing with someone like a mass murderer like Shipman, or you're dealing with some very substantial organisation like the Ministry of Defence with a huge budget, or the National Health Service likewise with big budgets, and serious things are going wrong, and then people cover them up. You've got to have some mechanism, because the concept, it's an age-old concept going all the way back to the beginning of things, is you don't grass. You don't sort of report people. It's a public school tradition to some people and so forth. And it's more than that. In the criminal fraternity, grasses, they are going to be killed, all sorts of things. But it's the old issue, which I find fascinating. I mentioned jurisprudence earlier because although this is about practical issues and to scholarly work, you do get down to the basic principles of legal theory. Let's talk about the book anyway, because Elizabeth, I think, did a very good job when we discussed this. And this is really what she says. Pity the plight of the poor whistleblower. In a not too distant past, it was positively hazardous for the well-meaning employee who spotted irregularities or wrongdoing in, say, a large organisation to blow the whistle, which in most cases required vast reserves of courage and conviction, and normally meant that you suffered, frankly, and you lost your job and you all sorts of things, and you got sneered at by people. Because one of the things is, in a social order, pecking order, grassing is not liked because it will affect your relationship with your colleagues. So if one could point a tentative finger at one area of law which is most likely to capture the attention and fire the imagination of the general public, whistleblowing would likely be it. There's little doubt then that practitioners and just about everybody else interested in this subject will welcome the latest edition of a long-established legal text on the subject, obligingly provided by OUP. It's the third edition since the first one came out some 10 years ago, and as always it retains its simple one-word title that's just as likely to capture the interests of the general reader as it has provided indispensable to the seasoned lawyer. And by the way, it doesn't take ages to type with the word whistleblowing out, unlike some of the very long titles that we review in other publication houses. We pay tribute, say the four authors, to the brave people who come forward to blow the whistle in the public interest. So saying, they stress that the heart of the legislation protecting whistleblowing is to encourage responsible whistleblowing when it is deserved, that is, and when it is indeed in the public interest. So there's a test, two-tier test in fact. They point out that the principal drivers for the publication of this new edition are those themes which emanate from the amendments affected by the Enterprise and Regulatory Reform Act 2013. Very unpopular with certain liberals and a lot of other people. It aims towards protecting those who blow the whistle in the public interest, as opposed to those whose disclosures relate to purely personal concerns. And again, you can see that that little litmus test, if you like, is a very important one. Public interest. If you ever tried, as I have, to get certificates, PII certificates, it's a nightmare. And I'm sorry, it's not about practice, it's always about politics and policy. And I'm not going to say any more than that, but I have seen how it operates and I'm not very impressed. Now, the core legislation in this field, however, is the Public Interest Disclosure Act 1998, a Labour piece of legislation, which the book examines in detail. So writing in the foreword, Sir Maurice Kay, former Vice President of the Court of Appeal Civil Division, reminds us that legislation should provide specific protection for whistleblowers is no longer controversial. For those concerned with corporate responsibility and good governance, this is good news. And in fact, if you think about it from any point of view, notwithstanding the jurisprudential argument, the basic legal theory argument, if you look at it from the point of view that it is a positive, because it means that in fact you're uncovering something where actually very serious damage could accrue if you haven't uncovered the problem and dealt with it, nipped it in the bud, if you like. So you can see the arguments both ways. And as you would expect, this new edition contains important new material, including detailed and extensive commentary on the 2013 legislation, as well as developments specific to the health and financial services discussed in the book's chapter 12. And yes, there's a chapter on the European Court of Human Rights towards the end of the book. It's about the jurisprudence of the Human Rights Court on whistleblowing in the workplace, because that really is where the problem can be. Remember all of the knock-on effects. You lose your job, you get ostracised, you have all sorts of problems with your colleagues. And if it's in an industry which is a little bit small, everyone knows each other, you're never going to work in it again. So you can see the problems. Will this be scrapped after Brexit? We ask ourselves. I doubt it. One is inclined also, of course, to hope not. But there's an awful lot of nonsense. I've recorded this. This review was written before the general election, and I'm recording this after the general election. We have a hung parliament. We are in a complete stalemate at the moment, and that's going to last for a long time. I do not see anything big happening for some years. So I think we can rest assured on that one. Let me conclude by saying thorough, erudite, readable and resource-rich, this definitive work on the subject of whistleblowing should be regarded as an essential purchase for human rights lawyers and, for that matter, all lawyers interested in this evolving area of the law. The publication date is cited at 2017. I'm not sure what the law, what the actual date for the law is itself. It probably doesn't say. I don't think I saw it actually say. Otherwise, the law is stated as at the 1st of December 2016. Well, I'm reviewing it in the middle of 2017 after the election. Wasn't sure what was going to happen. Not sure what's going to happen now either, but there we go. Just opening this book up in the middle. Vicarious and individual liability procedure. This is protection under the PIDA. There we go. A lot of detail. You can see the structure of the book again. Paragraph numbering. A few little footnotes. Not too much by way of footnotes, I hasten to add, which I think is good. Because one of the worst things is when half the page has got all the footnotes in. It gets a bit much after that. This is a lovely book. I'm really pleased. I'd like to thank Lewis, Bowers, Fodder and Mitchell very much indeed, and OUP. These books are very important for us as practitioners. We can't do our jobs without having this work. And they are actually opening up the debate. A much larger number of people now, fortunately, get a higher education. This book, and many like it, I think assist in trying to understand where we are and perhaps where we should be going. Thank you anyway to all concerned. Bye-bye.